This is chapter 8 from Law and Literature as prescribed by Mumbai University syllabus for first year BA LLB semester 1. We are reading chapter Some Reminiscences of the Bar by M.K. Gandhi 1869 to 1948. The Pursuit of Truth. About the essay. This essay is from Gandhi's book titled My Experiments with Truth. Gandhi's thoughts on truth are expressed in the following excerpts. The word Satya means truth is derived from Sat, which means being. Nothing is or exists in reality except truth. That is why Sat or truth is perhaps the most important name of God. In fact, it is more correct to say that truth is God than to say God is truth. Devotion to truth is the sole justification for our existence. All our activities should be centered in truth. Truth should be the very breath of our life. When once this stage in the pilgrim's progress is reached, all other rules of correct living will come without effort, and obedience to them will be instinctive. But without truth, it is impossible to observe any principles or rules in life. In spite, however, of such devotion and implicit belief in truth, what may appear as truth to one person will often appear as untruth to another person. But that need not worry the speaker. Where there is honest effort, it will be realized that what appear to be different truths are like the countless and apparently different leaves of the same tree. Does not God Himself appear to different individuals in different aspects? Yet we know that He is one. But truth is the right description of God. Hence, there is nothing wrong in every man following truth according to his own vision. Indeed, it is his duty to do so. Then, if there is a mistake on the part of any one following truth in this manner, it will be automatically set right. In such selfless search for truth, nobody can lose his bearings for long. Directly, if he takes to the wrong path, he stumbles and is thus redirected to the right path. Therefore, the pursuit of truth is true bhakti, devotion. It is the path that leads to God. In this essay, Gandhi speaks of following the path of truth, even in his professional work. Now we will continue with the chapter. Some reminiscences of the bar. Before coming to a narrative of the course my life took in India, it seems necessary to recall a few of the South African experiences which I have deliberately left out. Some lawyer friends have asked me to give my reminiscences of the bar. The number of these is so large that if I were to describe them all, they would occupy a volume by themselves and take me out of my scope. But it may not perhaps be improper to recall some of those which bear upon the practice of truth. So far as I can recollect, I have already said that I never resorted to untruth in my profession, and that a large part of my legal practice was in the interest of public work, for which I charged nothing beyond out of pocket expenses, and these too I sometimes met myself. I had thought that in saying this I had said all that was necessary as regards my legal practice. But friends want me to do more. They seem to think that if I described, however slightly, some of the occasions when I refused to sever from the truth, serve from the truth, the legal profession might profit by it. As a student, I had heard that the lawyer's profession was a liar's profession, but this did not influence me, as I had no intention of earning either position or money by lying. My principle was put to the test many a time in South Africa. Often I knew that my opponents had tutored their witnesses, and if I only encouraged my client or his witness to lie, we could win the case. But I always resisted the temptation. I remember only one occasion when, after having won a case, I suspected that my client had deceived me. In my heart of hearts, I always wished that I should win only if my client's case was right. In fixing my fees, I do not recall ever having made them conditional on my winning the case. Whether my client won or lost, I expected nothing more nor less than my fees. I warned every new client at the outset that he should not expect me to take up a false case or to coach the witnesses, with the result that I built up such a reputation that no false cases used to come to me. Indeed, some of my clients would keep their clean cases for me and take the doubtful ones elsewhere. There was one case which proved a severe trial. It was brought to me by one of my best clients. It was a case of highly complicated accounts and had been a prolonged one. It had been heard in parts before several courts. Ultimately, the bookkeeping portion of it was entrusted by the court to the arbitration of some qualified accountants. The award was entirely in favor of my client, but the arbitrators had inadvertently committed an error in calculation which, however small, was serious inasmuch as an entry which ought to have been on the debit side was made on the credit side. The opponents had opposed the award on other grounds. I was junior counsel for my client. When the senior counsel became aware of the error, he was of opinion that our client was not bound to admit it. He was clearly of opinion that no counsel was bound to admit anything that went against his client's interest. I said we ought to admit the error, but the senior counsel contended, in that case, there is every likelihood of the court cancelling the whole award, and no sane counsel would imperil his client's case to that extent. At any rate, I would be the last man to take any such risk. If the case were to be sent up for a fresh hearing, one could never tell what expenses our client might have to incur and what the ultimate result might be. The client was present when this conversation took place. I said, I feel that both our client and we ought to run the risk. Where is the certainty of the court upholding a wrong award simply because we do not admit the error? And supposing the admission were to bring the client to grief, what harm is there? But why should we make the admission at all, said the senior counsel. Where is the surety of the court not detecting the error or our opponent not discovering it? I said I. Well then, will you argue the case? I am not prepared to argue it on your terms, replied the senior counsel with decision. I humbly answered, "If you will not argue, then I am prepared to do so, if our client so desires. I shall have nothing to do with the case if the error is not admitted." With this, I looked at my client. He was a little embarrassed. I had been in the case from the very start, from the very first. The client fully trusted me and knew me through and through. He said, "Well, then, you will argue the case and admit the error. Let us lose if that is to be our lot. God defend the right." I was delighted. I had expected nothing less from him. The senior counsel again warned me, pitied me for my obduracy, but congratulated me all the same. What happened in the court we shall see in the next chapter. This ends this chapter from M.K. Gandhi's Some Reminiscences of the Bar. Discussions and few questions we'll go through from the textbook. I feel that both our client and we ought to run the risk. The questions are, what was the risk? The risk was of losing the case and the client having to pay a big sum of money. Why was it considered to be a risk? Because the arbitration order was already in favor of Mr. Gandhi's client, in spite of the arbitrator making a minor mistake of in the accounts, and if that error of commission or omission was admitted in the court, then there was a very high likelihood of the client losing the case or the order going against him. Third question is, what do these lines tell you about the narrator? Mr. Gandhi, when he said that we ought to take the risk of admitting the mistake done by the arbitrator in awarding the judgment in the client's favor, we see that M.K. Gandhi was all for the truth. He believed in speaking the right thing and admitting mistakes, even if it ought to go against his client's position. The second question is, the lawyer's profession is a liar's profession. Write a short essay expressing your views on this subject. Now each student can write in a different way. I will go through a few points. It is wrong to say the lawyer's profession is a liar's profession. That is like clubbing all lawyers in the same category. There are lawyers who would resort to lying or putting out or stating untrue facts in their plaint or in their complaint. But not every lawyer resorts to untruth statements. A lawyer's profession is one of repute. Each person with his own upbringing would act in a certain way by saying, just because the words lawyer and liar rhyme does not mean it is true. There are judges who are also there to pass the final judgment. It is not that a lawyer can lie and get his way. The judge will see through the lies, because even these lies needs to be proved in the court. And it is also not that the other party would let that lie pass through. Although in reality, there are many cases in which the lie still lying in a court would still make you win the case. But I feel that there is always an option to appeal. Even if you lose in a court, you can always challenge it in the higher court. Thank you very much for listening through. These were my thoughts. Do consider subscribing and sharing the link with your friends. Take care. Bye bye. Best of luck for your exams.